A very good morning to all the distinguished speakers and participants who are joining us today. I, Dr. Priti Parashar, Assistant Professor at Amity University, Noida, welcome you all to the day 2 and keynote session 3 of the 4th International Conference on Comparative Law 2023, organized by Amity Law School, Noida, Amity University, India, in collaboration with the School of Business and Law, Edwin Cowan University, Western Australia. The relevance of comparative law in the past few decades has been increasingly recognized. It has traveled beyond the frontiers of comparative constitutional law to emerging areas like information technology, family, business law, to name a few. Alan Watson, in his seminal work, Legal Transplants, An Approach to Comparative Law, asserts that legal transplants, which consist of transferring rules between legal systems, are a primary instruments of legal change. On a similar note, Professor D.D. Basu writes that comparison is a natural human activity and it is always an exciting experience to cross frontiers of one's own country and to travel to the other region. Comparison enlarges the vision and makes one grasp more firmly the essentials of one's own legal system. On this note, it gives me immense pleasure to introduce to the participants and the attendees to the distinguished, eminent keynote speakers joining us today. For keynote session 3, we will have with us joining distinguished academicians, including Professor Dr. Mark Graber, Professor M.P. Singh, Professor M. Padmavati, Dr. Ritumbara Manuvi. We would also be addressed by eminent industry persons and advocates, including Senior Advocate Pradeep S. Rai, the Vice President of the Supreme Court Bar Association, New Delhi, Ms. Samhita Chaudhary, the General Manager of the DS Group, and Mr. Alexander Hu, Ambassador Asia and Africa, Government of Vietnam. Without further ado, I welcome our first speaker, Professor Dr. Mark Graber, Regents Professor at University of Maryland Carey School of Law, United States. Professor Graber is one of the leading scholars on constitutional law and politics. Professor Graber was appointed as a Professor of Government and Law at the School of Law in 2004. In 2015, he was appointed as the Jacob A. France Professor of Constitutionalism. In 2016, he was named as the Regents Professor, only one of the 7 Regents Professor in the history of University System of Maryland. He's also an author of several pertinent books, including A New Introduction to American Constitutionalism, American Constitutionalism Structures and Powers, Forged in Failure, Rethinking Abortion, Transforming Free Speech, to name a few. With this, I would request Professor Dr. Mark Graber to address the gathering.
Well, thank you very much for that kind introduction. Please let me know if people can't hear me. One of the features of Zoom is it's sort of like talking into a great void. You say things, you hope people hear them and have some reaction, but you really have no idea. And to some extent, the experience of talking into a great void forms a subject matter of what I want to talk about today, because I am a science fiction fantasy fan, and a number of things people do in science fiction and fantasy that we also do as comparative scholars. The first thing we do, as Professor Parashar so eloquently stated, is we space travel. We go from place to place, trying to learn from other countries. Second thing we do is we time travel. We go back in time, trying to learn from the past. And a rather remarkable thing exists in the world of constitutional democracies. There are regimes like the United States, where I live in, where it is legitimate for judges and advocates to time travel. If you say this case was decided by the United States Supreme Court in 1803, it may well be relevant to a case the Supreme Court is deciding in 2023. But if you say this case was decided by the Supreme Court of India in 2023, it is usually deemed not relevant for what the Supreme Court is deciding in 2023. In other words, in the United States, we are allowed to time travel freely, but we may not space travel. In other regimes, most notably South Africa, space travel is encouraged. Supreme Court of South Africa particularly likes to travel to Canada, appears to have cited Canadian jurisprudence over 300 times. But it is not an originalist court. It is far less interested in time travel than space travel. And what I want to suggest to you today is that there isn't the real difference many of us make of space travel and time travel. In particular, a set of arguments Americans have made against space travel are no better than the arguments about time travel, that there is little empirical difference between the activity of space traveling and the activity of time traveling in constitutional law, that both serve similar purposes, and neither can serve the purpose of avoiding having to make judgment in decisions. So we start with some normative observations. In the United States, a great many people believe that time travel is far more authoritative, far more important to law than space travel. It's more important to law because Americans consented to the Constitution of the United States, not people on the Indian subcontinent. It's more authoritative, some people say, because it was supermajorities that consented to the Constitution of the United States in 1787, and supermajorities are really important. Finally, it's more authoritative because America is a distinct place. Now, maybe India is also a distinct place, but the crucial feature is because America is so distinct from the rest of the world, we ought to time travel back to New York in 1823, and we might learn something, but we really don't learn anything if we travel to New Delhi in 2023. Well, let's start with some problems with consent. We begin with the obvious one. Namely, it may be people calling themselves American citizens consented to the Constitution of the United States in 1787, but nobody who was alive today consented. People, we say, have a right to consent to the laws that affect them. Well, under ordinary understandings, laws don't affect dead people. So it may not be all that interesting to the authority of a law that dead people consented. But here, space travel may be more important. So, for example, the United States and China are in a diplomatic imbroglio over weather balloons or spy balloons, and that imbroglio may affect India, may affect China's policy to India. A great many things the United States does affects India. A great many things India does affects the United States. So, while we don't have very good arguments from consent theory as to why we should listen to dead people, we have very good arguments as to why the United States should listen to India when we understand our Constitution, and India should listen to the United States. It's also a question of what do living people consent to when they consent to the Constitution of the United States or the Constitution of India or the Constitution of Bulgaria. Doesn't really matter. Well, under one understanding, what they consent to is what the Constitution meant when it was ratified. But having taught constitutional law for 40 years, I'm fairly confident that most law students, when they come to law school, don't understand what the Constitution meant when it was ratified. Having read Supreme Court opinions, I don't think many justices on the Supreme Court really understand what the Constitution meant when it was ratified. A more accurate understanding of what people think they're consenting to is what do people generally believe? So if most countries, most places around the world think capital punishment is cruel and unusual, people are like to think if they've consented to the Constitution, it probably means capital punishment is cruel and unusual. In other words, people are as likely to think their national constitution means what most national constitutions of their time means than they are to think that their constitution means what it meant 200 years ago. They may say that, yes, I believe this is what the Constitution meant 200 years ago, but inevitably their vision of the framers are far more accurate of people around the world than what actually people thought in the 1790s. So there's no particular reason, if we take consent as our guidepost, that we would always engage in time travel and not engage in space travel. Well, let's look at majoritarianism. Here there's a claim by a number of influential American scholars that the reason Americans ought to abide by the original meaning and engage in time travel is that the Constitution of the United States was ratified by supermajorities, required 9 of the 13 states. Constitution of the United States is the toughest in the world to amend. You need a supermajority. And when you have a supermajority, it's more likely to be right than ordinary majorities. Or so the argument goes. Now, the argument is problematic even in its own terms. Namely, even if we look at 1787, it wasn't a supermajority that approved the Constitution of the United States. Voting was limited. You had to be white. You had to be a male. You had to be a property owner. You probably had to be a Protestant. That's not a supermajority. Moreover, it's not even clear supermajorities approved the Constitution. In many constitutional conventions, a majority of the delegates were originally for not ratifying the Constitution. They were opposed to it. They changed their mind, and it was never submitted back to the people. A number of the last states that agreed were coerced. But the problem of majoritarianism is more general. If we think majorities and supermajorities are more likely to be right, why should we confine our gaze to our country? Let us look at supermajorities around the world. Let us look at what are the rules in most constitutions. After all, particularly most constitutions that are approved by majorities or supermajorities of the people. And what will we discover, particularly if we're American? First, supermajorities overwhelmingly reject a life-tenured judiciary. The United States is the only country with a life-tenured judiciary. Nobody else has it. If supermajorities are more right than others, Americans ought to reject a life-tenured judiciary. The amendment rules in the Constitution of the United States are far more difficult than the amendment rules in almost any other constitution. Again, if we follow the rules of supermajorities and space travel rather than time travel, we get rid of the constitutional amendment rules. Most constitutions throughout the world include some positive rights. Government must actively intervene when citizens lack basic necessities. Constitution of the United States does not contain such rights. Again, if we follow the supermajoritarian rule, the Constitution of the United States ought to be understood as positive rights. Free speech is more absolute in the United States than it is anywhere in the world. In other words, again, it turns out the argument for supermajorities is a far better argument for space travel, to see where there are supermajoritarian understandings around the world about a good constitution, and not simply worrying whether 60% of the population in 1787 in one country agreed upon something. So then we move to the argument from exceptionalism. Under this understanding, the United States is a distinct country that is so distinct that we cannot import rules from another place. We are distinct in two ways. One, we're distinct culturally. It's sort of like, how can you import rules from soccer, which is the most popular sport worldwide, or cricket, which I understand is quite popular in India? You can't import those rules into American football. It just doesn't make sense. We're a different country. Same for free speech and life-tenured judiciaries. In other words, we have very distinct legal understandings. Our legal understandings on this view are rooted in very distinctive American ideas that, again, we can learn interesting things when we study foreign countries, but we ought not to import. Well, among other things, one problem with this is, why would anyone think the problems of New York in 1823 are more analogous to the problems of New York City in 2023 than the problems of New Delhi in 2023? It's an empirical question, and one might say, there probably are some similarities between New York in 2023 and New York in 1823, but there are also some similarities between New York in 2023 and New Delhi in 2023. It's not obvious to anybody that the clear analogy is between New York in 1823 and not New Delhi in 2023. Moreover, it turns out that the framers of the American Constitution were internationalists. American exceptionalism is a later view. So, as many of you may know, the American Declaration of Independence says, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their creator with certain inalienable rights. They didn't say that Americans are created equal. Who knows what Indians are? Who knows what Bulgarians are? It said all men. The Declaration of Independence begins with a statement of universal truths. When Americans protected free speech and freedom of religion, they didn't think they were protecting some distinctive American idea. They thought they were protecting things that people had as natural rights because they were people, and people in South Africa, India, Bulgaria are just as much people as Americans. That Americans, at least at the founding, believed in the law of nations. That is, there were universal principles that said, here are things nations can do, and here are things nations can't do. So it turns out the argument from American exceptionalism is an argument to space travel, to see how universal practices manifest themselves elsewhere, and not simply an argument that all we can do is time travel. There is finally an empirical argument that as Americans, we can know more about the past than other countries. You people speak strange languages. We speak a strange language to you. But of course, you speak a language. We can talk to you. Sometimes through translators, we can't talk to dead people. So again, it strikes me as just as probable that we will understand India as it is that we will understand the United States in 1787. Moreover, if you actually look, the problems of understanding the past are the same as the problems of understanding a different regime. We might imagine regimes as being structured in two different ways. First, there are a set of aspirations. What is it the United States is trying to achieve constitutionally? What is it India is trying to achieve constitutionally? What are your goals? What are our goals? Second is institutions. What are the institutions in India that are designed to achieve the values your constitution hopes to achieve? What are the institutions in the United States that are designed to achieve the values we want to achieve? Who are the people of India? Do they share those values? Can they operate the institutions? Who are the people of the United States? Do they share American values? Can they operate American institutions? And a good deal of constitutional theory is trying to deal with misalignments between people, institutions, and values. So in the United States, we had a constitution that declared everyone was entitled to equal protection, and a people, too many of whom believed that only white people were really entitled to equal protection. There was a mismatch between what the people believed and the goals of the Constitution. And I imagine you can think of mismatches as well. So one of the things we are doing constitutionally is trying to figure out how to align our people, our values, and our institutions. And sometimes we change our values, sometimes we redefine the people, sometimes we alter the institutions. A second feature of a constitutional regime is we have very big principles. All persons are created equal. We have specific manifestations of those principles. Everybody is allowed to criticize the government as long as they don't threaten violence. We have in-between principles, proportionality, category test in the United States. Well, it also turns out that our general principles, our in-between principles, and our paradigms don't align. And so again, we spend a lot of time trying to get them to align, and just when they think they were lying, new things happen and everything is thrown out of whack. Now, what is properly, I think, done? The study of comparative constitutional law. It is not simply the study of, well, here's how India solves this problem. Here's how Bulgaria solves this problem. It is not simply the abstraction of, here are the fundamental principles of the Indian regime. Here are the fundamental principles of the Venezuelan regime. What we are trying to do when we truly engage in comparative constitutional studies is map out the regime. Here are the aspirations of the Indian regime. Here are the institutions. Here are the people. How do they fit together? Here are their high principles. Here are their paradigms. Here are in-between. How do they fit together into a coherent whole? If this was a Wittgensteinian convention, I'd say, what is the life world of the Constitution in all of it, not simply a little piece of it? Turns out, what are we doing when we analyze the past? We're doing the same thing. We're asking ourselves, what were the values that this system was trying to achieve? What are the institutions? Who are the people? What were the high principles? What were the in-between principles? What were the paradigms? How do they fit together? How did they experience tensions? So the study of comparative constitutional law is the same as the study of the history of a regime. In some sense, historians say the past is a distant country, and that's exactly what we're studying. And what we study and what we learn are twofold. First, the song goes from an American musical, you can never go back to before. We can't create the life world of 1787. It's too different. There are too many factual understandings and sort of their great web of the regime we can't repeat. So a simple thing I said is, we can imagine, so we can say we believe in witches, but we don't. And we can never have the experience of people who believe in witches because we don't. The same is true when we travel abroad. There are differences between India and the United States, the way Indians put together their constitutional life world and the way Americans do, that there's no guarantee that the Indian life world will function and do the same things in the United States and vice versa. So what's the point? Other than being well-informed and showing off and becoming a professor, which is a wonderful life. Well, the mere fact that history and comparison doesn't work perfectly. One of the best ways to understand reforming your society is to step out of it. Look at another place. Look at another time. Ask yourself how they organize the world. Because the crucial feature in reforming a regime is the understanding that things might be different. It is one of the features of enslaving people or oppressing people is to convince them things can't be different. Comparative studies, history studies teach us things can be different. They give us ideas about the ways things might be different. We can borrow them, even if when we borrow a tool from India, it won't work the same way. When we borrow a tool from the 19th century United States, it won't work the same way. But it might help things become different, and we hope better. So we need, I think, to collapse the difference between time travel and space travel in our academic studies. We need to understand that both the comparativist and historian are largely engaged in the same endeavor. We need to understand that we can learn from the past. We can learn from each other, even if that will never compel us to do anything. Thank you very much.
Thank you, sir, for your enlightening words. Your legal analogy of time travel, space travel, and with reference to the consent theory is really would have broadened the mindset of our participants with regard to the relevance and limits of comparative law studies. Thank you again, sir. Now, I would like to welcome with us our next keynote speaker, that is Professor M. Padmavati. She's a professor at Rajiv Gandhi School of Intellectual Property Law, Faculty of Interdisciplinary Sciences and Engineering, IIT Kharagpur. She specializes in intellectual property. Prior to her association with Rajiv Gandhi School of Intellectual Property Law, she has been an associate professor at School of Energy Studies, IIT Kharagpur, and a senior scientist at Monsanto Research Center, Bangalore. In 2009, she was awarded the Microsoft Outstanding Young Faculty Award in Intellectual Property for creation of intellectual property resource with respect to traditional knowledge in India. With this, I would like to request Professor M. Padmavati to address the gathering.
Thank you. Thank you for the kind words. Very good morning or good evening, depending on the time zone, to all my co-panelists and the participants here. It's a pleasure to be in this international conference on comparative law. In fact, this is something which is a predominant discourse in the area of intellectual property law. So I'm pleased to speak at this forum today. I think I would be taking about 15 to 20 minutes time. Should be good to bring some thought into where are we hitherto moving into the area of intellectual property law. So when I was gathering my thoughts on what I'm going to speak on at this international conference, one of the important things that really came to my mind is what is the basis of comparative law when we do study them as academics, researchers, or even academicians. The objectives can vary, but one of the important things that I have seen over the 12 to almost 16 years of experience in this area, researching as well as teaching, is that comparative law is a dominant area of work in the area of intellectual property law. And why is it interesting to study comparative law? Going by the previous speaker, Professor Graeber mentioned very clearly that there are influences, but there are also distinct legal systems which have evolved over time. It may not be always very easy to compare. There may not be a basis to compare because of the differences and the perspectives. That's one viewpoint, absolutely. Now, when we come to the aspect of intellectual property law, why is it important to understand it on a comparative basis? This is something which is relevant for the discussion today. And why do we really look at the comparative basis of intellectual property law? I would like to draw on the area of work that we have been involved in understanding IP systems world over. There's one aspect of that national laws have been the basis of understanding the evolution and growth of intellectual property laws, which brings us to the aspect of looking at interjurisdictional diversity. It's desirable. The more the variation, the more the growth of the law in some sense. And we've also seen world over how the context of innovations, which form the basis of, or creativity, which form the basis of one of the important justifications of intellectual property, have been defined or have been explained in the individual laws. So it is not only important to look at the domestic context, but today it has become imperative to look at the cross-country perspective when it comes to intellectual property laws. And so what are the imperatives? Is it that we're looking only at the philosophical justifications? I think the more relevant thing, what I see, is the strong economic justification. And as we know, in the area of products which are based on IP, intellectual property systems have been nuanced based on the influences of the laws in different territories on how they support trade. What are the barriers when it comes to the entry of IP-based goods in each individual country? So therefore, we do see that there is an influence of an existing legal system in this paradigm. But normally, as an illustration, when we teach the particular aspect of intellectual property law, we not always start from the international basis. We start sometimes with a country basis. If you need to drive the understanding of where it all began, sometimes the country understanding has become relevant. For instance, in the area of semiconductor protection, TRIPS came only as a later development, but there were full-fledged legal systems when it comes to offering protection for semiconductors, which is just one example. Similarly, the patent system. Now, the interesting aspect of intellectual property laws, particularly in the area that our research group works on, is in the area of the techno-legal aspects. One predominant area that we work on is the area of patents, and the other is the area of geographical indications. So where do we see the paradigm of comparative law? If one needs to really understand the basis of different technology markets and what are the factors that affect those, one aspect is the intellectual property law in that particular country. So it is at this juncture I would like to mention that when we study comparative patent systems, we do see important differences, some similarities. So if you look at the context of contrasting and comparing legal systems in this area, there are certain important insights we can derive. One is on the nature and scope of subject matter, particularly in relation to patents. Whether you have an inclusive system or an exclusive system when it comes to offering protection for certain subject matter. And then, as you may be aware, in the area of patents, we also discuss criteria. Now, these criteria are similar across jurisdictions in the general context. However, we do see differences in the context of how novelty is interpreted, in the context of how inventive step or the non-obviousness understanding is there in certain legal systems. We also see the difference in the application of utility or industrial application. So this brings in a lot of diversity in the practice. This is also one system where we see an elaboration of guidelines. This is one predominant aspect of intellectual property where we see guidelines on every different type of subject matter. So there are also areas of work where guidelines are being also compared, and how that has affected the prosecution of patents. So when we look at the context of comparative laws in the context of patents, one question that I began with is, which I would like to now bring in, is hitherto where? That is, we now know the evolution of the IP system. In that we know how the patents system has grown over the time. And the greater the complexity of technology and the subject matter that is being claimed in these areas, we continue to see an elaboration of the scope. And because technology markets are now no longer country-based, they are global in nature, there is bound to be influence of one legal system over the other, because the economic basis is quite strong. So how do countries react to these different situations? And therefore, when we look at the elaboration of laws in any particular jurisdiction, it is not only important to understand the policy perspective, it is also important to understand in that the economic perspective, and in some instances, even the socio-economic perspective. So when we look at study of such a system, particularly in an Indian context, I would say, it is just but right that we necessarily work in the comparative law area. And there are reasons why we do that. One, if you want to have a clear and a basic understanding of the development of a law, as well as what are the factors that drive the enforcement, it is important to understand the background of it. For those who are dealing with product introduction, product enforcement based on IP, yes, it is important to understand how the laws are different. Today, in the area of patent prosecution, we are not dealing just with one jurisdiction. Often, and in the practice area, we are dealing with at least two jurisdictions. And there, it is important to understand jurisdictional considerations in relation to a specific subject matter. It's not just relevant only to patents, that's the case with all other IP as well. And the area has become quite complex because we do see announcement of guidelines which are changing, which are being updated. There's enormous case law, precedents. Patent law is ridden with that. And the interpretation sometimes is also quite varied because of the complexity of the techno-legal matters and the difficulty in interpreting the law, which is neutral, but the practice that has become very technology specific. So there we do see difficulties in application. Well, many nations had already had full-fledged patent laws much before the international cooperation. But one cannot miss the change post the TRIPS. TRIPS brought in the trade-related aspects of IP, compliance mandates that implementation of the minimum standards are there in the member countries. One of the important aspects of comparative law research is not just looking at the post-TRIPS mandate, but beyond TRIPS. We have different contexts that we look at. One is the development dimension. The other is the TRIPS plus mandate. And the third context is where we are looking at the free trade agreements. So when we're looking at these several contexts, we are looking at how the different perspectives can be sometimes difficult to interpret. A country which is a TRIPS member country on one end, is an FTA member, has its own socio-economic considerations. So when you look at the comparative law context, it is important to keep these insights. For any work that is being done in the comparative law research, which does not take into consideration the socio-economic considerations or the policy considerations, would just mean a bare comparison of the law, but not drawing important insights from the background of it. So it has been, personally, I should say, it has been a very interesting area for us to work in this. It's quite challenging to look at the cross-country perspective and understand how where are we actually heading to when it comes to the aspect of understanding similarities and differences in jurisdictions. There is a need for harmonization. There is also a need for distinctly patent systems growing within themselves. So uniformity in law may not be always desirable. As I mentioned earlier, the varied law and practice in some sense has strengthened patent systems. But in the global scenario that we work on, we do see the influence of one system over the other. And so when we talk about global manufacturing, then the context of whether a patent regime is effective enough to protect IP-based goods has become very relevant to understand. On the other end, from the market point of view, as countries begin to look at improving innovation ability, that also has a bearing on the national patent system. So sometimes we are also in this context looking at interpreting laws across laws which deal with innovation and creativity. This is also relevant for some of the new emerging areas of AI as well. I'll take you to the last part of what I wanted to discuss with you on the development of regulations or guidelines, particularly in patent law. Another area that we also work is in the area of GI. And why is it that patent system and GI system inherently different subject matter, but something which is similar of that is that both are based on a specification. A patent document describes the technology in relation to what is the invention that is presented in the form of a written description backed by the property in form of the claims. Now, a GI documentation also has a specification. This is one area that we find very interesting to work on, where we have guidelines that have been developed depending on each type of subject matter. And there is more to go. we do see continuous development of guidelines which clarifies the application of a particular provision in the context of a particular subject matter. So this is another area that we find interesting to work on. We particularly work on the US EP and the Indian system to study how the comparative developments are helpful in the enforcement. How do you see patent prosecution challenges when you work in a cross-jurisdictional context? And so therefore, today, as we see, there is a need for developing capacity in understanding comparative basis of law, because time is the essence. And if we understand patent prosecution from a cross-jurisdictional perspective, it is much easier to deal with how do you really effectively look at the protection of rights, and what are the guidelines that we need to utilize when we work in terms of the limits with respect to each type of subject matter. So this is an evolving area when it comes to the area of patents. We continue to see a lot of development when we understand the standards that are coming out. We do also see the interface of intellectual property laws with other laws. One of the other dominant area of work is the interface of intellectual property laws and competition, patents and competition, the information technology space. So there is a lot to achieve from the comparative research perspective. But again, as I mentioned, this is a very challenging area, because if you do not understand the social context, you do not understand the national policy context or the economic context, we may be dealing with something where we only have a partial understanding of with respect to any relevant country. So exceptions are another important area that we also work on, looking at what are the exceptions when it comes to patents and how are these fashioned under the patent law. The development of standards and the influence of these standards across jurisdiction. Often we do see, for instance, I can take an example, the SSR rule, which is what is used for interpretation of utility norms, has been borrowed from the US into the EU. Now, if you look at the context of the TRIPS agreement, this is just another illustration. We're looking at the aspect of Article 39 with respect to undisclosed information. And if one has to understand the basis of it, then one needs to get back into the understanding of the US law and how the definition of trade secrets, you see an imprint of that. And then today we have an EU directive. And what are the influences post-TRIPS and from the other legal systems into the development of the EU trade secret directive? I mentioned about semiconductor laws, protection for that. So these are just some illustrations to indicate that we do need to understand this paradigm. Today, as we see in the courts, for presumptive value, precedents across jurisdictions have been utilized. Because there are many things which are still unsettled in the area of patent law. And in order to really appreciate the evolving concepts, it's necessary sometimes to look at precedents across other jurisdictions. So to build the thought into the application. So this is again what is very interesting when it comes to comparative patent system. And we do experience this day to day. So today, when we teach students who study the patent system, it is but just imperative that we teach them on a comparative basis. Because today, when they go into the practice, they will not be dealing only with India. They will be dealing with US patents. They will be dealing with EPO and many more jurisdictions. So if they build that understanding at that level of study, they would be also able to appreciate the nuances of the prosecution in this area across jurisdictions. So it is challenging to study 3 different systems. But then from the practical standpoint, that insight is important when you really get into the practice in that area. We also see changes in the individual legal systems based on internal considerations, changes in national policy. Therefore, updating research in the area of comparative studies becomes also necessary. We have also country considerations. For instance, if someone is working in the area of biodiversity and is looking at IP based on bioresources, this is another illustration. It may not be relevant to tie up IP and biodiversity in a US context, but it becomes very relevant when you enter into India for a protection of IP on that. There is an interlinkage between the Patent Act and the Biodiversity Act 2002, wherein no person shall obtain patent in India, IP rather, under that patent, whether Indian or foreign, unless a no objection has been achieved taken from the National Biodiversity Authority. This is spelled out under Section 6 of the Biological Diversity Act 2002. So when you deal with this jurisdiction, then the operability of the law comes into picture, where you need to look at when patents on bioresources are being taken, we need the understanding of these both laws and therefore the compliance under it. So you would look at strategies to file a patent application at the patent office and then parallelly taking a no objection under the compliance mechanism under the Biological Diversity Act 2002. So today we need to appreciate this aspect of where across jurisdictions, the difference in the laws can affect products getting into the market, which is relevant for all technology markets, not necessarily only for pharmaceutical area. Also, when we look at forums, today forum in terms of decision making also has undergone substantial change. I'm deliberately not using court only as a forum. I'm keeping it open. There could be boards, trial under the patent office, and beyond that, the courts. So if you take it as a forum, as it is, you again see that there are influences. One example of that is the development of a post-grant review in the case of the US system. The post-grant review provides you the shortest time to oppose a patent, which is parallelly similar to what is in the EPO. So if there are entities prosecuting patents between the US and the EP. This is a very important development which helps. So the introduction of a post-grant review is a desirable system in the case of the US, which was already there in the case of the EPO. So this is an illustration to indicate to you that where do we see comparative influence of different patent systems. I will not go into the details of the cross-comparative work that we do in the case of GI, but there again we see very interesting insights. We particularly work on food GI, and there again we see a lot of interesting aspects that we could look at comparing and contrasting. And today, one of the important things that we are deliberating on is, do we need guidelines in India for GI? Based on the first GI registered in 2003 to today as we see. So there is a lot of room for work in the comparative research area in IP. I've restricted my discussion only to patents and most of it. And I think this is an area that we will see more and more work going on. And that hopefully should, as it has been, give us new insights into the development of different legal systems. I think I'll stop at this. And if there are any discussion points, I'd be happy to take them. Thank you so much.
Thank you, ma'am, for this very intellectually stimulating discourse on IP law and comparative studies. Ma'am, the question that you asked, hitherto where, is something that our participants will take with us as a very important guiding point in legal research and understanding the relevance and the challenges to comparative law studies in future. Thank you, ma'am. I would like now to welcome our next keynote speaker, Professor MP Singh, the Chairperson, Center for Comparative Law, National Law University, Delhi, and the former Vice Chancellor, West Bengal National University of Juridical Studies, Kolkata. Professor MP Singh is an eminent name in the area of comparative public law, including and especially constitutional law, administrative law, human rights, and legal systems. Professor MP Singh is a fellow and a visiting professor at several institutions of international repute, like Max Planck Institute of Comparative Public Law and International Law, Heidelberg, Renmin University of China, the University of Hong Kong, National University of Singapore, and Jawaharlal Nehru University, New Delhi. He has also been the director of Indian Law Institute, New Delhi. His publications include several pertinent books, including the German Administrative Law and Common Law Practice, Common Law Perspective, Comparative Constitutional Law, Legal Dimensions to Market Economy, Human Rights and Basic Needs. Without further ado, I would like to welcome Professor MP Singh to address the participants.
Sir, mic is off. Yeah.
Am I audible now?
Yes, yes.
Oh, thank you, Kriti, for introducing me so elaborately. Actually, as I am getting old now, many of the things which I could do before, I can't do anymore. And somehow, because a request came and then it was told that I could speak from home, it became slightly important for me that let me return to a university where initially, when it was started, I was asked to be the dean of the Faculty of Law. But because already I was dean at the University of Delhi, I did not want to disturb the two universities simultaneously. So therefore, so far as I am concerned, so far as the topic for today is concerned, I think let me introduce myself, which Kriti has already introduced in a way that I have done some work on public law, not on private law. And therefore, my comparative law actually is public comparative law rather than private comparative law. We heard recently Padmavati ji on issues relating to patent law, and I think that was a marvelous way in which she explained all the things. Now, so far as comparative law in general is concerned, basically distinctions are drawn between the public law and the private law. And so far as common law is concerned, that is considered generally as the public law, that the law has resulted from the state and not from the private individuals. It is not that the activities of the private individuals were taken into account. Rather, it is the activities of the judges from the very beginning, which became important so far as the common law is concerned. And therefore, whatever judgment they gave ultimately from the very beginning, even when there were disputes between two private persons, whether it was tort or it was a contract or it was a criminal act, the judges used to actually take the views of the people from that area, and then they used to convert them into what may be called as precedents. And therefore, precedents had to be followed. And that is how, from precedent to precedent, in a way, you may say brick by brick, the common law has been made. And it remains, continues to be actually the state law instead of private law. And that is how, so far as the state law is concerned, it developed or evolved itself as a law relating to the state. And therefore, from precedent to precedent, the law is developed. So far as the civil law is concerned, I'm talking basically of these two broad or important systems, the civil law and the criminal law. So far as the civil law is concerned, it is basically private law. That is, the any rules actually were considered to be based on some moral principles as prevailed in the society and as could be worked out by the people in general rather than the state authorities. And that is how, so far as the civil law is concerned, it is basically a law of the people. And this law is now, unlike the common law, which you have to study so far as you have to study from the cases. So far as the common law is the civil law is concerned, civil law has to be read from the legislation and from codification. That is, the codes have been implemented, and they are the major laws which cover the entire area of the civil law or of the criminal law. And accordingly, those codes are the basis for or the foundation for the law. These codes actually are based, unlike the common law, not on technicalities. Rather, they are based on principles of morality for a society. And therefore, there is also a close relationship between law and morality in the civil law system, while that does not exist so far as the common law is concerned. Now questions are being raised whether constitutional morality, for example, is being raised, whether there is something like constitutional morality which should govern the decisions of the courts. But that remains again disputed, whether constitutional morality should be developed as an independent basis for the decisions of the courts, or we should actually ignore so far as the constitutional morality is concerned and decide the cases strictly on the basis of law as it is given in the constitution, or it is given in the interpretation of the courts. So the common law actually has been made from case to case, and that is how you have to sometimes go back into the cases which have been decided several hundred years back, and they become the important decisions for the purpose of determining a point which which happened today. And it may be possible that the principles which have been decided long back in the present context, they may look as if they are irrelevant, or they are not relevant in the context of the current society. And for that reason, therefore, the question is that whether we will continue to follow the civil law system or the criminal law system, common law system. We have inherited common law system, and the two systems, basically civil as well as common law system, out of the many other systems which exist in the world. Basically, these two systems have developed from Europe. Whether it is common law system which developed in England, or it is the civil law system which developed basically in Rome, and in course of time it became part of the entire Western Europe, on which made so in a way, so far as the civil as the civil law system is concerned, civil law system is much wider and is followed by more people than the common law system. But again, so far as the application of these systems is concerned, that has depended on the basis of which country was ruled at some point of time by which European country. And therefore, if it has been ruled by common law country, England, then of course it is the common law system which is applicable in that country. And if it is a case of rule by a civil law country, Rome, for example, in Europe, covered almost the entire Europe, and as a result of that, the civil law system has become basically the foundation of those countries where the European countries, whether it is France or Germany or any other country, those which have ruled in any of these countries, that has become the law for those countries. This is how the two systems have widely operated in different parts of the world. That is, the countries where the civil law country ruled, that became a civil law country, and where the common law ruled, that is British system, that became a common law country. That is how the common law and the civil law have become the major concerns so far as comparative law is concerned. But that does not mean that there is nothing else for common law. Common law actually applies, for example, not common law, but generally, so far as comparative law is concerned, whether there are matters which are relevant irrespective of who was ruled by whom, whether they were ruled by a European country or they were ruled by Britain, that becomes to some extent relevant, but at the same time, there are other laws which are applicable in certain areas. And for example, so far as India is concerned, its family laws and its customary laws, irrespective of the fact that common law is the law of this country, but that is that operates in the area of public law only. So far as the private law is concerned, whether it is family law or it is certain customary laws, so far as those laws are concerned, actually they are the laws which are customary practices, and they are private laws. You may put them in the category of private law. All the changes which, for example, have been made in Hindu law, they remain areas applicable only to Hindus and not generally to all the people. Now there are discussions on whether there can be a uniform civil code for the country. That would be introduction of the civil law system if we succeed in doing that. But it remains still a kind of disputed issue whether it is possible to have a civil law system so far as this country is concerned, or the common law system will operate. But that does not mean that there are not other systems. China, such a big country, has its own traditions. Chinese legal system, therefore, has its own uniqueness in number of matters, though, of course, it is a modern state and therefore modernity has to be brought into it. But at the same time, this is also a fact that there are lots of practices which are basically Chinese and unique in their application. And one of them has been that still the Chinese people, and particularly so far as the Japanese people are concerned, they, irrespective of the fact that they have been influenced by the European civil law system, irrespective of that, so far as their principles relating to law are concerned, they remain is still operative, and one of them is the mediation. That is, instead of going to the courts, people in these countries prefer to decide their disputes amicably within the society or among the people. And if that can be solved, that remains to be the most respected procedure for that purpose. Going to the court is considered to be a kind of something which may be called as antisocial. And therefore, someone who is going to the court, he is indulging in some sort of antisocial activity. And therefore, basically, people still prefer to mediate rather than going to the courts. And even if they go to the courts, even in the courts, actually, mediation is done by the judges, rather than that both the parties, the judge actually comes down from his pedestal and sits with the parties on a table which is available near the pedestal, and there he discusses with he or she discusses with the parties, and then the matter is decided according to whatever the parties agrees upon. And normally it happens. I had the opportunity of going both to China several times as well as to Japan, and I found that courts normally are hardly anyone is seen in the courts, and most of the matters, even except perhaps the criminal matters, the matters are decided by the courts through mediation, and people still prefer to, instead of having a court mediation, that mediation should be done in the community itself or between the parties itself. And that is considered to be a most honorable way of doing things. But there are other legal systems also. Islamic legal system is operative in various parts of the world to some extent, here also in India, that we have these personal laws for Hindus and personal laws for Muslims. And as a result of that, the two laws operate according to the religion of the person, and not a general law which is applicable to all persons in this country. Now, going, so there are other systems also in Africa, for example. There are lots of countries where some practices which are unique to those countries, although most of them, these countries were subjected either to the West European countries, or they were subjected to the rule of Britain, Great Britain. Wherever Great Britain entered, definitely some practices of British public law were introduced in those countries. And similarly, so far as civil law countries are concerned, the civil codes or civil practices were operated in those countries. So therefore, these two systems are actually dominant systems throughout the world. That is the common law system and the civil law system. But civil law system is considered to be a comparatively more systematic and closer to law and morality. And as it has grown through writings from the very beginning during Roman law, 12 tables are known. So from the very beginning, it was a written law. Therefore, most of the law has been codified in these countries, and the judges actually have to apply those codes into specific cases when they are brought before them. But so far as the common law is concerned, it is still considered as a public law from its origin. And still the judges go by the precedents which the courts have decided earlier. It is not codified, and the codification actually, though of course, so far as India is concerned, British actually gave us several codes: Civil Procedure Code, Criminal Procedure Code. These codes, and so far as the law of contract, law of transfer of property, evidence, number of things they gave to us, but they were all given on the principles which had been laid down in common law system in England, and the same system was made applicable to this country also. As a result of that, we still look to the precedents in England, how the matters have been decided, or in countries where common law prevails, like United States, Canada, or Australia. These are the countries, major countries where common law operates, and the system of common law continues to remain the dominant system so far as India is concerned. A lot of work has been done on major legal systems of the world, and these legal systems basically are studied more by, not as much by the common law people as by the civil law people. So whether it is Rainy David or Brierley, or it is these other books, Swigart and Kurtz, Glenn, all these books are basically written by persons who are from the civil law countries, or have the civil law country, or have the knowledge of operation of the civil law countries, including, for example, Mensky, who is basically a common law person, but originally he comes from Germany. Therefore, his foundations are stronger so far as Germany is concerned, rather than in the common law system, and that is how the scholars from the civil law countries, they continue to actually promote the comparative legal studies or comparative law, and that is how it becomes important. So I think with these observations, I stop here. I don't think it is necessary that I must go into further details of the system. With that, I stop. Thank you very much for giving me the opportunity. I'm sorry that I have not been as systematic as I should have been, but it is because of, apart from age, other responsibilities. Yeah. Thank you very much.
Thank you, sir. Thank you, sir, for drawing the attention of our participants to a very significant area in comparative law studies, that is the difference between the common law and the civil law countries, and the difference in approaches in judicial pronouncements in public law and private law. Thank you, sir, for your enlightening words. Now I would like to call our next keynote speaker, Senior Advocate, Mr. Pradeep S. Rai. Mr. Pradeep S. Rai is the Vice President of the Supreme Court Bar Association. He has over 25 years of standing at the bar in the Supreme Court of India, various high courts, commissions, regulatory bodies, and tribunals. He has an experience in litigation across a wide spectrum of civil, criminal, revenue, and constitutional issues. He has also been the Vice Chairman of National Anti-Doping Agency. Having a very deep-seated passion for access to justice, he is the President of the Society for Human Rights and Civil Liberties, a leading body in human rights organization. He's also the trustee and chairman of the Indian Legal Research Foundation, another pertinent organization for the members of the bars as well as students. Now I would like to welcome sir to address our participants.
Thank you, Kirti ji. Honorable Dean ma'am, officials of the MIT University, Professor Yam Padmavati ji, and Sumitra Singh ji, and Biju Joseph ji, all these dignitaries, Miss Jane Matthew ma'am. Actually, when we talk about the comparative law, we have to go into the history. And that history, I'm not going into the ancient history or medieval history. There also, they used to practice some international examples, and they also used to go by the precedents. But the first example, when we come to know, that was during the time of Justice Mahmood. Justice Mahmood, who was the son of Sir Syed Ahmad Khan, who became the judge of the High Court those days in Allahabad High Court at very young age, at the age of 32. And he was known as a dissenting judge. But most of the dissents which used to come from him was completely based on the comparative law. He used to get the foundation, he used to get the arguments and the precedents from the various other courts, and especially even House of Lords proceedings, because sometimes the similar matters decided with the same facts, one in the facts with the Indian subjects and one with the facts of the UK nationals. It was found that judgments are different. One is based on fundamental rights, one is based on civilized society, other one was based on because of the particular conditions and the environment in which the country is being ruled. So he passed so many orders by giving it. Like one example I will give, that once the case was brought before him, in which if you do not have the English translation of the previous order, your matter will be dismissed. That kind of orders were used to be passed. But when he sat with the British Chief Justice Corn, he decided that no, this is not it is violation of the fundamental right. And he cited the House of Lords proceedings only, in which he said that if language should not be the bar, this is your responsibility to provide translated copy, because subjects are not obliged to learn the language. And that's how this system started. But you see, nowadays we find in our Supreme Court, in various high courts, and not only in India, but other countries also, that they are citing the judgments of each other. That may not be part of their constitution, their procedure code, but absolutely, when they start using these findings based on rule of law, due process, it means that we are being enlightened, especially when we are framing the arguments, when we are arriving on the judgments, and completely at par with the nature of constitutionalism and comparing with the other societies and facts. But at the same time, we have sixth schedule of the constitution in India. Sixth schedule means that when the ethnic society is there, when we find that there are tribals are there. So especially for the tribal administration, we have created sixth schedule, because there are certain areas where we can't interfere, where customary law has to prevail. In those matters, when it was being framed, despite having the constitution, when sixth schedule was actually formed, so many member of parliaments had objected. They said that such provisions in the law or in the constitution will not be tenable, and in the long run, it may not be useful for the country. But ultimately, now we have found that because of these 371 section and several provisions of sixth schedule, the local administration has been strengthened, and gradually those parts of the nation has come closer to our country. So that is the way, that is the study, and that also we got it from several other provisions. Like you see, prior to the sixth schedule, there was so many other problem, especially because they Nagaland, Manipur, or the Mizoram, they did not want to come to India. Even Meghalaya, and all of them have different practice. All of the tribes, even in hardly in 50 kilometers, you will find completely different language, of which the other side is unknown. So that's how this system evolved. So sometimes on the basic principles, like when you follow the traffic rules, passport, international police, or criminal investigation, and even airlines, all these matters, like citizen identification. So on all these issues, you need a comparative law, what has been decided, what has been held, but at the same time, we have to have a clear differentiation between the customs and between the basic practice and procedure of that particular nation. So, like, we have also adopted so many good things from abroad, like fundamental rights, we got it from the US. Similarly, the parliamentary system, we got it from the UK. But it is not that we got it from there. We were already ruled in that system that was engrossed after 1909 Act, and then 1935 India Council Act. It was a foundation was already there. So when you are actually going into it, when you are going for the parliamentary system of governance, Then so many other things prevailed. And now we are citing Privy Council, we are citing House of Lords, we are also looking after these other countries. Even now we see that many judgments from Indian Supreme Courts, which has been passed by many our learned judges, that is being cited abroad. And even this arbitrations and all, you see, we have created that because civilized society has to come with some good ideas, which gives you a kind of perception in which the other investors, other your economic interests, your fundamental rights, your human rights, that has to be protected. You see this, like this Dubai court, the Dubai International Financial this center. Why they created this? Earlier, it was only for the financial disputes and especially the small causes matters. But thereafter, what happened? They have given all the financial disputes to these centers because you have to create an environment. If you don't have a business environment, then your country may not attract the investment. So a country which is in the Far East, they are Middle East, they are practicing this kind of law, this kind of system, and we are also gradually going for it. Like arbitration awards of Singapore, we are recognizing it. Whenever the awards come, we have to be mostly our high courts and Supreme Court, they don't interfere at all, because we have to give the credibility, we have to give a message to the investors that such kind of practice, such kind of procedure is in the process, and government of India and or any other government, unless they follow a general principle of humanitarian law, unless they follow a kind of developmental law, they can't succeed, they can't grow. So, and even economic offenses, you see now there's Interpol into existence. More than 100 countries are signatory. And now the Indian police officers are heading the Paris department. Somebody is Indian police officer is heading in the USA. Some US officer is in India. So that's how this system is working. So all these systems are going to work completely in the process of comparative law. Unless you follow the international law, which has to marry well with our IPC, CRPC, and Indian system, your acceptance will not be there. So the time has come when when I feel that at one point of time, within the next 10 years or 15 years, I see that you will find that most of the offenses and the sentence, there is some equivalency. Like you see 377, it was an offense for a long time. After this Supreme Court judgment, they have decriminalized it. Only this is a ground of divorce. But not only this, so many other foundation and fundamentals, like internet is now fundamental right. In Jammu Kashmir issue, it was held. So how it came, because in US courts, they have decided like this. Then society is emerging like that. Then Madam Padmavati, she referred about this trademark and this intellectual property and copyrights. You understand, you see that unless you recognize all this, you will not have the proper system. You will not have the proper recognition that you are a law-abiding country. So all these things are happening. You see our copyright and trademark matters. Now we all are getting importance in such matters, and they are recognizing our trademark and copyright. Like once your trademark is well known, they are also accepting it. Otherwise, initially, even on this small, any kind of fruit also, like mango and all, they have already trademarked and copyrighted. So many concepts, many stories, many things that is there. But what concepts are now growing? Like my body is my right. That concept was not there in India at all. Now it is there because of the international judgments, international pronouncements, international deliberations. So we all are adopting good things. And any country, even be Taliban, they all want something good for the country. They all want something which is completely conversant with the fundamental rights. They all want to do something good to the nation. But in that good may not be good for the other person. So whatever is suitable to us, that we have to accept. Like I remember this 2G case, we all know that this is the one of the biggest scam that was politicized and published in all the newspapers. But when you go into detail, you will find that this is not only a scam, but this is also a kind of breach of constitutional morality. Another country who is believing on Indian conflict is signing an agreement with you because of licenses provided by you. And then they find that government of India, which granted license to a company, that a company was not eligible for that. So whether you have to rely those documents or not, thereafter there is a policy decision within the government that they will not interfere in any kind of investments which has already happened. Because you have to rely on the government document. All the deals were signed on behalf of presidents of India. When President of India is the party and he has signed some document, or his representative has signed some document, how can you go take in something otherwise? So gradually we are also growing. We are also getting matured. We are also realizing the right to privacy. Now you see we have social media. I mean, social media, all these handles, even this communications, that is not in control of India. The base is somewhere else. But unless this comparative law is there and such practices are in place, you can't protect yourself. You can't file a litigation against them. So though for the collection of taxes and revenues, the companies has made an India chapter. But despite that, they are governed by some foreign national only. Like iCloud, Apple phone we all are using. So iCloud is completely in control of the US government. And with a small correction, a small notification or order of the government, they start roaming around here and there, and they file litigations. And they say that we are trying to curb free speech. All these things are happening. I don't want to take much time, but similarly, you see the environment matters. Now we have NGT in place. This NGT is not our concept. It was a green matter. We never thought that there will be a question, especially on the issue when the government is taking an action in regard to construction of the road. And then there is a kind of threat to the environment. But for those matters, we have NGT. TDSAT, you see, all these airlines law has been transferred to TDSAT now. Consumer matters. All these consumer rights, it was there earlier, but again, we are policing it day by day. So we have to recognize so many things, and we have to learn from comparative law. We have to learn from international law, and we have to also learn from the precedents. We have to learn by the pronouncements. And that is the right way. Our constitutional amendments so far, like even Panchayati Raj to Panchayati Raj to emergency provisions, even to the 356 provisions, all these provisions are brought. But even it was brought, that has to, they started working completely on the practice and other parts of the nations, other part of the world. So even this strict scrutiny, then slavery, genocide, there are certain things which cannot be questioned, for which you have to consult the other presidents and other countries' law, and you have to improve your version by the other pronouncements. But there are so many other areas where if you feel that if you start interfering, if you start taking the notes from the other countries, it may not be acceptable. But mostly I feel that 2/3 of humanity, they have the common practice. And in such common practices, such kind of laws and involvement of those pronouncements will be very useful. So it's very good. I congratulate the team of MET to organize this program. It is really good that you all are raising an issue, especially on comparative law, which is normally law colleges, they fear to pick and they fear to raise. Thank you so much for inviting me. I am also enlightened by the words of wisdom of Professor MP Singh, Padmavati ji, and other dignitaries. Thank you so much.
Thank you, sir. Thank you, sir. So thank you, sir, for discussing with us the change in the approach of the courts in India as well as around the world with regard to law in foreign jurisdictions. This is an aspect of international comity between nations, which is an important part of comparative law studies. Now I'd like to welcome our next speaker, Dr. Ritumbra Manuvi. She's an assistant professor at the University of Groningen, Netherlands. Prior to this, she has worked as a university lecturer in the University of Groningen for 3 years and as a consultant in B&B Associates. She's also an executive director of the London Story. She's also the executive director of the London Story, an organization which is looking into research, advocacy, and political mobilization for an inclusive world. The organization is particularly working in the area of combating hate speech and inclusive citizenship. I welcome ma'am to address the participants of the ICCL 2023.
Thanks a lot. Good morning, everyone. It's quite an early morning at my end, but I hope still a morning in India. Before I begin, I would like to extend my gratitude to Amity Law School, India, and the Edith Cowan University in Australia for organizing the 4th annual International Conference on Comparative Law. I'm grateful to the organizing committee, Dr. Ashok Chauhan, Atul Chauhan, Professor Shukla, Professor Bandyopadhyay, the conference chairs, Professor Tomar, and Professor Aston, the conveners and co-conveners of the conference, Dr. Jane Iyer Matthew, Ms. Rupendra Singh, and Ms. Kirti Parashar, and several other members of organizing committee who extended their warm welcome to me for speaking at the occasion. As I was going through conference material sent to me ahead of time, I also noticed my own mentors, specifically Professor MP Singh, listed as a distinguished speaker. It gives me immense pleasure to join his company to talk about comparative law to our audience today. I was asked to speak on a topic of choice, so today I want to speak to you on the topic of artificial intelligence and law. This is an area of work which is still developing in my own profile, in my own research profile, where I look at the use of AI in the healthcare sector. Before I go into the subject matter, however, I want to take a moment to allude to the origins of modern comparative law, which can be traced back to Gottfried Wilhelm Leibniz in 1667. Leibniz, in his book, Methods of Studying and Teaching Jurisprudence, wrote about the classification of legal systems into families, something that we still do while teaching our students about civil and common law systems. Later on, Montesquieu, which I think everybody is aware of in the legal fraternity, in his work, De l'Esprit des Lois, cultivated the idea of cultural life of the society, which is governed by the law. And this aspect of cultural life of the society becomes fairly important when talking of the comparative law. For classification and comparison of laws and legal systems, Montesquieu spoke of the appearance, the quality of soil, the principal occupation of the natives, the degree of liberty to the regions, the riches, the numbers, the commerce, and the customs have on determining the law that governs the people and their political nature. Now, taking this leaf from the history, if we move forward towards the era where we have artificial intelligence living amongst us, breathing, living, and learning amongst us, we can imagine that it is going to be a game-changing situation. It will not only impact how we work, but the very fabric of our culture and our societies. It will impact our occupations. It will impact our religions, the riches, the numbers, the commerce, and the customs. It will also perhaps impact the degree of liberty that we have, specifically when we talk of surveillance technologies. Our interaction with each other, our interaction with the lived environment around us is going to change because of the artificial intelligence. It may change for better, it may change for worse. We still do not know, and we still have to see. However, we do know this, that we need to implement and regulate the AI. But as it comes out, AI is also fairly hard to implement or to regulate because it is a self-improving, self-learning system. We do not fully comprehend how this self-evolving system is going to look like in the future. So how must we compare a system which is forever changing and forever evolving? This is a question that baffles most of us in the Western world. Although I believe in India, where we are culturally aware that the change is the only thing that is permanent, this question may feel less daunting. While speaking of AI and comparative law, much of the comparison comes in between the race to control AI between China, US, and Europe. Each of these political regions are not just making progress in development and deployment of AI, but also in regulating the markets to monetize the AI. One can imagine, especially in case of Europe, that monetization does lie at the heart of regulatory environment, especially since the formation of EU itself was an act of monetization of European-wide resources. In 2019, European Commission laid down its white paper on artificial intelligence, a European approach to excellence and trust. Through this white paper, the EC set out its mission to foster the development and uptake of a safe, lawful AI that offers legal certainty, a favorable investment climate, and an innovation optimum across digital single markets. While respecting fundamental rights, ensuring inclusive societies outcomes, protecting citizens' well-being, and safeguarding our common humanist moral values. However, since then, much of the efforts of the EU Digital AI Act has been towards controlling the idea of monetization. This idea of how we can maximize the benefits that one can gain out of AI, while also hoping that it will respect the fundamental rights of everyone else and not just the shareholders of the big companies. EU considers US to be its key global partner, and this is not just because of the development and the deployment of AI in both these geographies, but also because of the historic reasons and the transatlantic harmonization that both the regions have always wanted. This has also a lot to do with their cultural identities as white nations. But what about India? Where does India stand in comparison when it comes to regulating AI? Do we share the same beliefs towards monetization? Or do we allude more in much greater sense towards the human rights protection? Are we even at a stage where we can effectively regulate not just the deployment of AI, but also the development of AI, specifically when we speak about data protection and the data which goes as ingredients towards making a successful AI? In terms of current development of legal paradigm, my guess is as good as yours. We are aware of the difficulties in regulating US-based technology companies that operate in India and at times consider themselves above the laws in India. And I believe the speaker ahead of me also alluded to these very facts, that how difficult it has been in regulating these tech companies and asking them to open up their algorithm black boxes to show us what is going on. One thing that I can say from a comparative perspective towards the future development of law in the domain, while the European and US law may develop from the point of monetization, influenced deeply by their neoliberal market economy, I believe and I hope the laws in India will develop from the point of equality, liberty, and dignity that forms the basis of our political existence. And with this, I would leave you with this food for thought of where does the comparative nature of these countries will go ahead in future when it comes to the legal development in the domain of artificial intelligence. Thank you.
Thank you, ma'am, for discussing with us this very relevant issue of artificial intelligence and law. It is very interesting to notice the different legal opinions with respect to artificial intelligence in European Union, United States, and the developments in India. With this, we come to the closure of keynote session 3. I would like to express my heartfelt gratitude by presenting citations in the honor of our distinguished speakers for taking out time to address our participants.
Kriti ma'am, you can just make the closing remark and then we'll read the citation.
Okay, ma'am. We'll have the signing of MOU thereafter?
Yeah, we'll have the signing.
Okay. Okay, so again, I thank all the speakers for enlightening us today. And today's discussion, we have noticed that with the rising of democracy, individual liberties, the recognition of human rights, and the development of international law as well as globalization, there has been a rising relevance of comparative law beyond national frontiers. We've discussed varied views with regard to intellectual property, with regard to practical application in the courts, artificial intelligence, then again comparative constitution. In this regard, David Walker has written that comparative study is valuable for parting the study of any legal system into perspective and deepening the understanding of one's own system. This is in tune with what our keynote speakers have already deliberated on today. Today's session has not only broadened our perspective on comparative positions in multiple legal issues, but it has also made us gather a more deepened understanding of the Indian legal system. With these words, I would like to thank our keynote speakers again, the participants and the attendees for joining us. Now, we shall move on to the signing of MOU. Since industry interface is a very important component of education, on this
ma'am, just a minute, we'll just read the citation.
Okay.
I am not able to share it with you. I'm not sure what's the issue. So नहीं मैम मैं अभी शेयर कर रही हूँ.
Okay. Ma'am, can you see the citations now?
Yes. Okay, ma'am, you can read it out, ma'am.
I'd like to present the citations to our distinguished speakers. The first citation, this citation is presented to Professor Dr. Mark Graber. He's the keynote speaker in the keynote speaker session of International Conference on Comparative Law on Saturday, the 11th day of February 2023. Professor Graber is a constitutional law and is an expert in constitutional law and has inspired various scholars across the world. His vigor and enthusiasm in the matter of constitutional politics gives an insight into his dedication on matters of constitution. We are thankful to Professor Graber for inspiring us with his motivating words and taking out his valuable time. We hereby recognize the contribution made by Professor Graber and extend our sincere thanks to him. Thank you, Professor Graber. Now, the next citation is presented to Professor M.P. Singh in the keynote session of International Conference on Comparative Law on Saturday, the 11th day of February 2023. Professor Singh is a renowned academician and an expert in constitutional law with a zeal for doing more in the area of law. Professor Singh has been instrumental in inspiring many to do research for understanding the nuances of comparative law. We are thankful to Professor Singh for an insightful message and gracing this occasion. We hereby recognize the contribution made by Professor Singh and extend our sincere thanks to him. The next citation is presented to Professor M. Padmavati in the keynote session of International Conference on Comparative Law on Saturday, the 11th day of February 2023. Professor Padmavati is a distinguished professor of intellectual property with several years of research experience in biodiversity. Her keen interest in bringing change in the matters of intellectual property is evident from the passion she showcases for the promotion of understanding to the area. We are thankful to Professor Padmavati for investing her valuable time and enlightening us with her words of wisdom. We hereby recognize the contribution made by Professor Padmavati and extend our sincere thanks to her. The next citation is presented to Senior Advocate Pradeep S. Rai in the keynote session of the International Conference on Comparative Law on Saturday, the 11th day of February 2023. Mr. Pradeep is a senior advocate and vice president of the Supreme Court Bar Association. He has a deep-seated passion for ensuring access to justice and bringing a change in the society. He has several years of standing experience at bar in litigation across a wide spectrum of civil, criminal, revenue, and constitutional issues. We are thankful to Advocate Rai for investing his valuable time and enlightening us with his words of wisdom. We hereby recognize the contribution made by Advocate Rai and extend our sincere thanks to him. The next citation is presented to Dr. Ritumbra Manuvi in the keynotes as a keynote speaker session of the International Conference on Comparative Law on Saturday, the 11th day of February 2023. Dr. Manuvi is a lecturer of undergraduate courses on fundamentals of law and social movement and has contributed to the digital policies. In her research, she focuses on digital information sphere and formation of new norms in digital societies. We are thankful to Dr. Ritumbra for inspiring us with her valuable insights and sparing her precious times amidst us today. We hereby recognize the contribution made by Dr. Ritumbra and extend our sincere thanks to her. Now, I would like to request my colleague, Dr. Sumitra, to take forward with regard to the signing of Memorandum of Understanding.
I'll just take this moment just to give a formal vote of thanks to all the dignitaries who have come for the keynote session 3. Now, we have with us all the dignitaries, where we started off with Professor Mark Graeber, though it was at a very odd time for his session that he did log in for the session. I sincerely thank Professor Graeber for having accepted our invite and gracing this occasion and giving us an insightful address on the issues relating to constitutionalism. I would also like to thank Professor MP Singh, though in spite of his health issues and he was able to make it through. There was a time when we thought that he would not be able to join, but then it was somehow we were able to get Sir to join this session. I'm most humbly thankful to Professor MP Singh. In spite of his busy schedule and his health issues, he has joined us and also given us a lecture on the facets of comparative constitutional law. We are very much obliged to Professor MP Singh. We do have Professor Padmavati who has joined us and who actually took us through the various aspects relating to intellectual property. Ma'am showcases her intellect and also the interest with which she has this passion for bringing in a change and for others to learn about these new facets of law. It is too inspirational for all of us. We are grateful to Professor M. Padmavati for accepting our invite and for gracing this occasion and for delivering the keynote address. Thank you so much, ma'am. We are also thankful to Ms. Senior Advocate Pradeep Rai for having graced this occasion. Sir has accepted our invite for being a guest speaker for this keynote session 3. We are highly obliged to Senior Advocate Pradeep Rai for gracing this occasion. We are also indebted to Dr. Ritumbra Manuvi, who has accepted our invite, though I think it was at a very last moment that we did ask her to join, but then she gracefully accepted our invite and she has she was there in our midst for granting us a lecture on the various aspects relating to social media and the aspects of law relating to her field. We are thankful to all the dignitaries who have graced this occasion. Thank you so much to all the dignitaries and to the participants and students who have joined us today morning for this session. I would like to close this keynote session 3 on a note that the spirit will go forward in terms of hosting the international conference on comparative law in the years to come. And we look forward to seeing all the participants and the students and dignitaries at the next session also in 2024 too. On this note, I would like to end this session, and we'll have the signing of MOU at 11:30. So that that session will start only at 11:30. So have a great day, all of you. Thank you so much.
Honorable Chairman, sir, with your permission, and Honorable Joint HOI Aditya Tomar, sir, with your permission, can we begin with the MOU signing ceremony?
Please.
Yeah. So good morning, everybody, and welcome to the 4th edition of the International Conference on Comparative Law 2023. Once again, in this session, hosted by Amity Law School, Noida, together with Edith Cowan School of Business and Law at Perth, Western Australia. So right now, what we are going to see is an MOU signing ceremony. As Honorable Prime Minister of India, Mr. Modi has venerated that India's G20 agenda is going to be all-inclusive. It is going to be ambitious. It has to be action-oriented and decisive. He says, and I quote that, let's all join together to make India's G20 presidency of healing, harmony, and hope. So let's work together to shape a new paradigm. And that would be the paradigm of human-centered globalization and to promote the universal sense of oneness, believing in one earth, one family, and one future. So keeping this in mind and with the vision of Honorable Founder President of Amity Education Group, Dr. Ashok K. Chauhan sir, and our Honorable Chancellor, Dr. Atul Chauhan sir, we are now, with their blessings, going to sign this MOU, keeping in mind that we are going to create industry-ready professionals at Amity Law School, Noida, who are going to work to make world a better place by integrating academics and industry. So to begin with this session, I would now request Professor Dr. Aditya Tomar, Joint HOI and Additional Director, Amity Law School, Noida, to welcome the guests.
Thank you, Dr. Sumitra. First of all, I would like to welcome to the Amity University formally to Mr. Vineet Visa, Group General Counsel, Tech Mahindra Limited. Most welcome, sir, formally, as we are getting your help since long in the form of our board of studies, faculty studies, and the placement. And I would like to take the privilege to welcome our new friend, Rajiv Vasant Vijay, Chairman and Managing Director, Mivis Knowledge Park Private Limited. Most welcome you, Vasant, sir, to the Amity family. I would like to extend my warm welcome to our Honorable Chairman, Dr. D.K. Bandyopadhyay, sir, who's the guiding force since 2016 with the Amity Law School. He is designated as a Chairman, Amity Law Schools, and the Chief Advisor to Founder President Office. Before that, he was the 3-time Vice Chancellor with the state universities. Under his guidance, we are just promoting the idea behind the new education policy 2020 that all the student must be industry ready. So in the alignment of new education policy, though the legal education is not new education policy is not binding on the law education and the medical education, but our chairman always try to promote to the student to be industry ready. That's why we started the Amity Law School. Noida is the first law institution who established CRC, Corporate Resource Center, where we are just providing the support not only in the term of placement to develop their personality and to make them industry ready. So with these words, I would like to welcome to Chairman Professor Dr. D.K. Bandyopadhyay, sir, Mr. Vineet Vij, Mr. Rajiv Vasant, sir, Thank you very much for your kind presence. Sumitra.
Thank you so much, Professor Dr. Aditya Tomar, Additional Director in Joint HOI. You're also the in charge of Corporate Resource Center at Amity Law School, Noida, and with your guidance, CRC is moving every day ahead in terms of great linkages with industry, and we are very thankful that we've again come to one session where we are going to sign the MOU with two more industry partners today, and in the presence of Professor Dr. D.K. Bandyopadhyay, sir, who is respected and honorable Chairman of Amity Law School, Noida. So, Chairman, sir, I will now request you to speak a few words before we formally sign the MOU. Over to you, sir.
So, thank you, Sumitra. At the outset, I must, express our gratefulness to Mr. Vinit Bhijji and Basantji for extending their helping hand in signing these two important MOUs with the Amity Law School, Noida. Now, we are all working here, Mr. Bhij and Mr. Basant. We are working over here with the one vision, that how Amity universe in its entirety, in its totality, we can give the best of the quality education based on the value-based quality education to our students. And we try to do anything and everything to achieve those goals, so that when the students they pass out, they are not only become the industry ready, but also go out with a happy mind, with a happy face, with a happy life that they are going to enjoy in the days to come. So with this philosophy in mind by our Honorable Founder President, and also the statement given by our Honorable Chancellor that Amity University is a student-centric university. Whatever we do it, whether we are doing research, whether doing teaching learning process, it is all centered towards our student. And for that matter, we go on inventing, because invention is not only in the laboratory, but invention is also in the processes. We go on inventing our different types of processes in this university. Now, before the Bar Council has taken any view about this NAP policy, because they have not come up with anything related to the law education, but certainly, like any other progressive university, with the guidance and directions of our Honorable Founder, that we go ahead. And all the time, I say to our founder, to everybody in every forum, that what Amity thinks today, the rest of the universities or rest of the educational management center, they think tomorrow. And now with these thought processes, we are going ahead in terms of signing different types of MOUs, so that our student gets the in-depth understanding of those organizations through the process of internship. And that internship essentially will lead them to understand what is the ground reality. We teach them in the classroom, we bring them industry persons to interact with them, we bring the honorable judges to interact with the students and to rub shoulder with each other. And in addition to that, we see that if we can have some MOU with the n number of institutions or n number of organizations, the students get the access to those organizations in understanding them, and better understanding them, better finding their theories to be applied. Most important thing is that. Now, question is coming that what is the win-win situation? For us, our winning situation is that how do we make our students learn, most importantly learn, and they become industry ready. This is our winning situation. What is the winning situation for the organization with whom we are studying, we are signing the MOUs? For them, they are going to get the brilliant mind, because here our selection process is very stringent, and the brilliant mind they are getting, and they will also feel that they can also bring some changes within that organization. And subsequently, if they found to be suitable for them, so that they can find their placement in those organizations. Because every organization placement has a cost. So this will also reduce their cost of recruiting this manpower. That is also another direction with which we work out. Now, this philosophy is clear. We know what we want to achieve to, and we are also making our partner to know what actually we are looking forward. And then the marriage can take place. If we say something, if our partner, they feel other way, then marriage cannot take place. So we want the marriage. We want the marriage of our own interests, marriage for the benefit of the students, marriage for the benefit of the citizens of the. Now, with these words, once again, I welcome Basantji and Vinitji on this virtual platform. We would have loved to see both of you on the campus, signing the agreement across the table, exchanging a cup of tea with each other, and then finding the next opportunity, so that some of us can visit to your organizations. So with this view, now I request Sumitra to take the proceedings ahead.
Thank you, Professor Dr. D.K. Bandyopadhyay, respected Chairman, Amity Law School, Noida. Ladies and gentlemen, boys and girls, and everybody who has joined us online through different portals of Amity University, Uttar Pradesh, Noida, Mahatma Gandhi says that truth will never damage a cause that is just. And Amity Law School, Noida believes in truth and justice. As Honorable Chairman Sir said that we need to have common values in order to be together. So we are very grateful that today we are signing the MOUs, and our founder president, Dr. Ashok K. Chauhan sir, has wished us all the very best to sign this MOU. And now, with the blessings of Honorable Founder President Dr. Ashok K. Chauhan, and with the permission of Honorable Chairman Professor Dr. D.K. Bandyopadhyay, and with the good wishes and blessings of our three joint HOIs and additional directors, Professor Dr. Aditya Tomar sir, Professor Dr. Arvind Bhanu sir, Professor Dr. Shefali Raizada ma'am, we now finally sign the MOU. I would request my colleague and friend, Mr. Rupendra Singh, to help me by sharing the screen. Ladies and gentlemen, today Amity Education Group is a bigger group of research and innovation, and today we have more than 17 global campuses, 11 universities, 26 schools and preschools across the globe, and this MOU is signed between Amity University, Uttar Pradesh, Noida, and Tech Mahindra Limited, which is a company incorporated under laws of India, which is having its registered office at Mumbai, and this MOU is signed between Tech Mahindra Limited and Amity University, Uttar Pradesh, Noida. They are the parties of this MOU. So what are the mutual promises that both of us make today? This will be based on the promises that together on 11th of February, we believe that, number one, we are going to establish the channels of communication and cooperation and discuss the areas of common interest and objectives that would be for the benefit of the student community by the way of enhancing the skills and knowledge on the best endeavor of basis. Tech Mahindra to create internship and industry training opportunities for 4 to 8 weeks term for the students. Such program will be intended to give insight to the students in the different areas of law and latest developments. Amity University, Uttar Pradesh, Noida to offer opportunities to Tech Mahindra officials for campus visits, participation in seminars and conferences, to be a part of the industry advisory board or any such board or committee or the panel at Amity University, Uttar Pradesh, Noida for the advancement of students and the university, guest faculty and lectures to the students on contemporary topics in order to prepare the students to have smooth transition from academic to the working career. So this MOU shall be valid for the period of 2 years with effect from January 1, 2023 till December 31, 2024, and either party may terminate this MOU by giving 30 days prior written notice to the other party informing of its intention to terminate this MOU. So this MOU that we are signing is highly confidential, as is mentioned in the document that is being signed today. And the governing laws and jurisdiction will be the laws in India. So any dispute arising out of this MOU shall be settled amicably between both the parties. And this MOU shall not be assignable by either party without the prior written consent of the other party. No modification, amendment, and supplement or to waiver of this MOU hereto shall be binding upon the parties, hereto unless made in writing and duly signed by both the parties, and the other clauses are mentioned in this document, which we signed today in the presence of 3 HOIs of Amity Law School, Noida, Professor Dr. Aditya Tomar sir, Professor Dr. Shefali Raizada ma'am, Professor Dr. Arvind Bhanu sir, in the august presence of none other than our chairman, Professor Dr. D.K. Bandopadhyay sir, as the party from Amity Law School, Noida, together for Tech Mahindra, Shri Vineet Vidji, signed today on 11th of February on this online portal. Congratulations both the parties for signing off the MOUs. Many congratulations. Together, I think we will be able to fulfill the vision of our Honorable Founder President, Dr. Ashok K. Chauhan, who believes that every student of Amity should be an asset to the society and the nation and the globe. So I will now request my dear friend and colleague, Rupendra sir, to proceed with signing of the MOU with our another industry partner, that is MIBIS Cyber Forensics Laboratory Private Limited. Ladies and gentlemen, today, the 11th of February, we signed the second MOU with our another industry partner in the 4th edition of International Conference on Comparative Law, hosted by Amity Law School, Noida, and Edith Cowan School of Business and Law at Western Australia. Amity University, as I said, is a very big research and innovation group. Today, we have more than 16 global campuses, 12 universities, 28 schools and preschools, and MIBIS Cyber Forensics Laboratory. MIBIS Knowledge Park Private Limited is a company incorporated under laws of India and having its registered office at Tattvamsi, Kerala, Trivandrum, Kerala. And this MOU is signed between Amity Law School, Noida, Amity University, Uttar Pradesh, and MIBIS Cyber Forensics Laboratory, and the scope shall be the same as it is with the other industry partner, that is to establish the channels of communication and cooperation and discuss the areas of common interests and objectives that would be for the benefit of the student community by way of enhancing their skills. And MIBIS is going to create industry and internship training opportunities for 8 to 4 weeks term of the students, and Amity University of Uttar Pradesh is going to offer opportunities to our industry partner MIBIS Cyber Forensics Laboratory at Trivandrum, Kerala, and that they will be the part of the industry advisory board or any such other board or panels at Amity University Uttar Pradesh for the advancement of the students in terms of making our students industry ready. Again, this MOU shall be valid for a term of 2 years with effect from February 11, 2023 till February 10, 2025, and the either parties can terminate this MOU by giving 30 days prior written notice to the other party informing of its intention to terminate this MOU. The information is highly confidential as is mentioned in para 3, clause 3.1, 3.2, subclause 1, 2, 3, 4, and 5, and that there are laws and jurisdiction governing this MOU, and this shall be governed with the laws in India, and this MOU shall not be assignable by either party without the prior written consent of the other party, and that the parties shall remain independent parties and nothing therein shall be deemed to cause this MOU to create an agency, engagement, partnership, or joint venture between the parties. Neither party shall have any authority to bind the other to any other matter of undertaking. This MOU is signed for Amity University, Uttar Pradesh, and the signatories are Professor Dr. D.K. Bandopadhyay, Chairman, Amity Law School, Noida, together with our 3 HOIs, Professor Dr. Aditya Tomar sir, Professor Dr. Arvind Bhanu sir, Professor Dr. Shefali Raizada ma'am, and for MIBIS Knowledge Park Private Limited, we have with us Mr. Reji Vasant Vijay, Chairman and Managing Director, MIBIS Knowledge Park Private Limited. Congratulations, MIBIS Knowledge Park Private Limited, and congratulations, Amity University of Uttar Pradesh, Noida. Congratulations, our 3 HOIs and our chairman, sir, and both of our industry partners. It's said at Amity that once an Amitian is always an Amitian. So today, you also become a part of the Amity family. Yes, with the MOU in formal agreements. Congratulations, both the parties. Over to you, Aditya, sir.
So I just want to pay my regards and thank you to both the parties. So with the hope that in the future we will organize the planning and trainings to the welfare of students. Now, Chairman sir, you want to say?
Vinitji, can you say a few words?
Thank you so much. I think it's a honor and a privilege and of course, a pleasure to be here today. And thank you to get me into this august company. I think we all very well know Amity University, one of the top-notch universities, the great rankings. And we've also witnessed Amity alumnus doing wonders in different streams. And my personal association with Amity goes back to almost a decade. I think I started with a conference and then it's just grown. We've really worked very closely on some programs, including some internship and other activities. It was recently that our CEO and Managing Director, Shri C.P. Gurnani, was also awarded an honorary doctorate degree in the convocation in 2022.
Yes.
But this MOU is really, while we've had a relationship, I think, but this formalizes and maybe creates another platform for us to cooperate, to see how do we benefit the student community. I think that's the theme. It's important, as the host just pointed out. I think it's not just important that these students have a degree, qualification, but I think it's very important that they are appropriately made industry ready. They are upskilled. They get the right exposure so that they are kind of job ready. It helps them as a smooth transition from academic to, say, in their working careers. So the careers could be multifold, but my personal experience has been wonderful with these students that I've interacted. Some of them placed with us. Dr. Tomar has been instrumental in quite some work that we've done. Thank you, Dr. Tomar. Thank you, Manopadhyay and other respected people. But I think we are really very keen, and we are looking forward to this MOU, seeing how do we expand. And just to summarize, I think we look forward to coming and having a cup of tea very soon. We are very close to your campus, just behind your campus, actually, and invite members to our establishment, see how the students who pass out actually get to work. So we are there. We, as I just mentioned, to conclude, we are in multiple disciplines. We support almost all the top companies. We are a top-notch company in the IT space, part of the Mahindra Group. We are in over 50 countries. So I think the lawyers who work with us, coming from Amity and many other prestigious universities, get to work, have an exposure on international laws of different jurisdictions, practices, compliance areas, and so on. So I think we are very excited, and I look forward to a wonderful association. Thank you so much. All the best.
Vinitji, I'd like to add one sentence here. Our honorable founder, president, and chancellor, they say that MU should not be a piece of paper. MU should be seen that yes, we have developed the relationship, and we believe in those type of relationship.
Thank you, Mr. Manopadhyay. We have a relationship already, so I think
yes, we have all. Now we'd like to strengthen the relationship in structured form.
Absolutely, absolutely, wonderful.
Now, Basantji.
Yes, sir. So it's a
word from you.
Yes, sir. It's really a pleasure to be part of the team, and to start with, like what you told, you all look, it's a student-centric. What you have been focusing. We are also working on a knowledge-centric for the last 2 decades. Because we started during the days of Y2K, and as one of the pioneers in e-learning, we started. Now we are into forensics, and because we are also research-based, and we give much because maybe it's like we have a couple of projects also, basically with the vision of Dr. APJ Abdul Kalam sir, and taken the guidelines of TIFAC, Department of Industrial Scientific Research, and Sam Pitrode's guidelines when he was the chairman of National Knowledge Commission. So we are also built on a base of research, and we give the students, maybe if we take 2 decades back, we have been focusing much on e-learning, and when we are now on the path of forensics and security with cyber law, we are delivering our best, and we look maybe in the years to come, we will be much happy to be part of, and we can work together to generate a new enlightenment citizenship. That is our core focus, and which maybe for the last several decades we are working on it, and our team are much focused on it, and we are really happy to be part of your team.
Oh, thank you very much. Thank you indeed. Thank you indeed. Let us now write down a new chapter. New chapter, because we are totally convinced in Amity that academia and industry must work hand in hand. Then and then the future citizen of the nations, they will be highly benefited. And this is is a more or less in a consensus among all the faculty members, all the authorities, all our persons who matters, including founder president and our chancellor and vice chancellor, that yes, we must be in a position to give the students learning through doing, so that they become industry ready. I mean, all these MUs that we are now actually targeting essentially to achieve those dimensions. So thank you very much, and for agreeing with our proposals, and you also came forward. So we say that in the relationship, I extend my hand to you, you extend your hand with me. Then we joined our hands together, and then we say that from today we are together. So thank you very much.
Thank you so much, Chairman sir, Mr. Vineet and Mr. Vasant. And thank you, Aditya sir, Arvind Dhanu sir, and Shifali ma'am in being a part of this MOU